cyber crime on some woman or girl, then the question is under what law it is punishable and where, what, how and to whom should she report. This is the basic question. You take the precautionary measures, but in spite. So what is the legal mandate against the gendered cybercrime is mainly covered in 4 acts, and the 4 acts are: number 1, the IT Act 2000. The first is the IT Act 2000. When I discussing about the information technology, that is the IT Act 2000. The second is the Indecent Representation of Women Act, Prohibition Act, that is 1986. It was enacted in 1986. Then third is the Indian Penal Code 8060, and fourth is the Protection of Children from Sexual Offences Act 2012 and amendment in 2019. So first we will start with the Information Technology Act. The purpose of enacting this law, information technology, is to provide legal recognition to the transaction carried out online, and second is to mitigate and prevent cybercrime. In this act, about 16 different acts of person are covered and punished under the gendered cyber violence. The first is if the culprit dishonestly or fraudulently, without the permission of the owner, accesses, downloads or copies or extracts or introduces any virus into the computer system, or damages, disrupts, denies access to the authorized person to access, or provides any assistance to facilitate access to any person, and if he charges the services availed to the account of another person by tampering it, or destroys, deletes or alters any information residing in it, or steals, conceals, destroys or alters any computer source code to such computer or computer system or computer network or computer resource, it is an offense under the IT Act. And the offense is under section 43 read with section 66. The definition is in section 43 and the punishment is in 66, and the punishment is imprisonment up to 3 years or fine up to 5 lakhs. So in all the online violence cases where the culprit gets unauthorized access or deletes, destroys and disrupts in the computer resource of the victim, this section is attracted. Then second is access or communication is made by the accused through a fake identity. Section 66C is applicable. You can see on your screen, and the punishment is 3 years imprisonment and with fine up to 1 lakh rupees. Now another is if the culprit captures, publishes or transmits the images violating the privacy of the women or the victim without her consent, then it is punishable under section 66E, and this is very common. In the hostel there was a concealed camera where the students live in. Such cases do occur because they don't know it is punishable under the IT Act. So this is the punishment is for the violation of privacy, and the punishment is 3 years imprisonment under 66E. Now then comes the culprit publishes or transmits any obscene material in the electronic form. It is punishable with 3 years imprisonment and fine up to 5 lakh rupees on the first conviction, and if he repeats it, then the imprisonment enhanced up to 5 years and the penalty is up to 10 lakh rupees. Now if the culprit publishes and transmits such obscene material which contains sexually explicit text, it is in the electronic form, so the offense is punishable under section 67A and the imprisonment is 5 years. In the 67 it was 3 years. It is a 5 years and the fine is up to 10 lakh rupees on first conviction, and subsequent conviction the imprisonment is 7 years and the fine is up to 10 lakh rupees for the subsequent conviction. Now, section 67A, next, these are three sections, 67, 67 and 67B. And in 67B, where the culprit publishes or transmits material in any electronic form which depicts children engaged in sexually explicit act, or number 2, conduct or create text or digital images, collects, seeks, browses, downloads, activities, promotes or advertises, exchanges or distributes material in any electronic form depicting children in obscene or indecent or sexually explicit manner, or cultivates, entices or introduces children to online relationship with one or more children for and on sexually explicit act, etc., on the computer resource, or facilitates abusing children online. This is a very exhaustive section. Children on record in any electronic form on abuse or that the other pertaining to a sexually explicit act with children, it commits this offense under section 67B, and it is punishable with 5 years of imprisonment and 10 lakh rupees fine, and on the subsequent conviction, the conviction is 7 years. So, this section 67B is very exhaustive. In case of cyber violence, another section of the privacy, in case of cyber where the culprit was in confidence with the victim, accessing her personal information. As we saw in the previous session, there was a case of a girl going to the coaching center and she was be friendly with the boyfriend, and he took the photos and personal photos and all that, and then he made it public on the internet. So the cases of cyber violence where the culprit was in confidence with the victim, accessing her personal information, and later on, because of the differences, the accused with revenge discloses her personal information. This section 72, that is called the breach of confidentiality and privacy, is applicable, which is punishable with imprisonment up to 2 years and or fine with 1 lakh rupees. So, any offense under the Information Technology Act, now who will investigate it? The important section is 78. So, any offense under the Information Technology Act shall be investigated. I say it is shall be investigated by a police officer not below the rank of inspector, as it is mentioned there in the section, and the police officer should be not below the rank of inspector. That is important. And second, it authorizes the police officer of and above the rank of inspector to enter any public place and search and arrest without warrant. These are some of the important sections related with the gendered cyber violence. The second act is the Indecent Representation of Women Prohibition Act 1986. Under this act, publication or exhibition of any advertisement or sending by post of books, pamphlets, etc., or production, sale, let to hire, distribution, circulation or sending by post any book, pamphlet, paper, slide, any film, writing, drawing, painting, photographs, representation or figure with contains indecent representation of women in any form is publishable under section 3 as well as section 4, and the section 3 and 4 are punishable under section 6. Imprisonment is up to 2 years and with fine 2000 rupees in the first conviction, and in the subsequent conviction not less than 6 months of imprisonment, which may extend to 5 years, and also with fine not less than 10,000 rupees but up to 1 lakh rupees. So that is there in the Indecent Representation of Act. There are only 3 sections, but very important, and the offense is cognizable under the Indecent Representation of Women Act. Now, the most important is the Indian Penal Code. Indian Penal Code has certain sections to cover the gender cyber violence, and the sections related to gender cyber violence which are punishable, and the section is, it is 166A, then it's 292, 293, 294, 313, 326A, 26B, 354, 354A, 354B, 354C, 354D, then 375, 376, 376A, 376B, and 376AB, 376C, D, DA, 76DB, 376E. It has been recently amended just to cover all that. Section 499 and 500, 506, 7 and 9. We start with 166. What does that say? Section 66A, public servant disobeying direction under law. What is the direction given to the police? He will register the FIR, cognizable offense, which is reported to him at the police station. That is the duty of the police officer. So, knowingly disobeys any direction of law which prohibits him from requiring the attendance of at any place of any person for the purpose of investigation into an offense or any other, or knowingly disobeys to the prejudice to any person any other direction of the law regulating the manner in which he shall conduct such investigation, or fails to record any information given to him under subsection 1 of section 54, 154, registration of FIR of the CRPC in relation to cognizable offences punishable under 326A, then 326B, 354, 354B, 370, 70A, 76, 76A, B, C, D, E, and 509. These are some of the offences in which the investigating officer is supposed to go to the victim's place, need not to call at the police station. So, these are mentioned in the various laws and CRPC also. So, the cognizable offence and the punishment is 6 months to 2 years plus fine, minimum 6 months, and it is bailable, it is not compounded. Now we start with section 292, and 292 is the sale of ऑप्शन बुक्स. अक्सर आप देखते हैं कई दफ़ा ऑप्शन लिटरेचर आपको बुक्स के रूप में मिल जाता है, तो आईपीसी के अंदर इसका ये सेक्शन 292 के अंदर ये पनिशेबल है आप, और इसके अंदर ये लिखा है कि कोई भी इस सेक्शन में कोई बुक है, पंपलेट है, पेपर, राइटिंग, ड्राइंग, पेंटिंग, रिप्रेजेंटेशन, फिगर or any object shall be deemed to be obscene if it is lascivious or appeals to the parent interest of, or if it affects anybody who sells, lets to hire, distributes, publicly exhibits, or in any manner puts into circulation or for purpose of sale, hire, distribution, public exhibition or circulation. ये इस तरह का कोई करे, या कोई इम्पोर्ट एक्सपोर्ट और कन्वेज एनी ऑप्शन ऑब्जेक्ट फॉर एनी पर्पज और एफ्रो, तो वो उसका अंदर, या उसको रिसीव करे, उसके प्रॉफिट को रिसीव करे, या उसको यानी बेचे तो कोई दूसरा लेकिन मालिक कोई दूसरा हो, तो उसके प्रॉफिट को यदि रिसीव करता है तो उसके अंदर भी उसके कहते हैं, या कोई एडवर्टाइज करता है और makes known by any means whatsoever that any person is engaged or is ready to engage in any act which is an offense under this section. ये इसके वो किया है, और ये सारे के सारे उसके अंदर जो किया है, तो उसके अंदर आपको 2 साल तक की सज़ा यानी इम्प्रिजनमेंट इसके अंदर है फॉर टर्म विच में एक्सटेंड टू 2 years और विद फाइन विच में एक्सटेंड टू 2000 रुपीज़, ये इसके अंदर वो किया हुआ. देन नेक्स्ट सेक्शन आपका आ जाता है 293. स्टूडेंट्स नो वन कॉग्निजेबल मीन्स where police can take action without the permission of the magistrate. So then section 293 that deals with the obscene object to the young person. 292, obscene material selling and all that. And 293, whoever sells, lets to hire, distribute, exhibits or circulates to any person under the age of 20 years. The age is 20, children is here in this IPC section 293, the age is 20 years, and such obscene object as referred in such and such, the same thing, and the punishment is up to 3 years and plus fine, and it's a cognizable offense and it's a bailable offense. Then section 294, 292, 293, 294, these are regarding the obscene act. So this is obscene acts and songs. This is important. Whoever to the annoyance of others does any obscene act in any public place, or sings, recites or utters any obscene song or words in or near public place, shall be punished with imprisonment with a description which may extend to 3 months. The punishment is very small, but the police can take action without the permission of the magistrate. It is a cognizable offense. 294. Then it is 313. It is regarding the gendered violence. So causing miscarriage without women's consent, that is an offense under section 313, and the imprisonment is 10 years in this. Then comes section 326A, that is the voluntary causing grievous hurt with the use of acid. This section was amended and 326A was added into it. So whoever causes permanent or partial damage or deformity to, or burns or maims for, disfigure or disables any part or parts of the body of a person, or causes grievous hurt by throwing acid, it is punishable with imprisonment of either description for a term which shall not be less than 10 years. It is so grievous section. So not be less than 10 years, but which may extend to imprisonment for life. So the imprisonment is severe here. Then section 362B, that is voluntary causing grievous hurt by using acid. If the hurt is grievous, then the punishment is minimum 5 years, but which may extend to 7 years, and it's a cognizable, non-bailable, not compoundable. Important is 354. 354 is the assault or criminal force to women with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman intending to outrage or knowing it is likely to that it will be there to outrage her modesty shall be punished with imprisonment to either discretion for a term which shall not be less than 1 year, but which may extend to 5 years. That is for outraging the modesty, 354. Now 354 has been amended as the requirement of the time, and then in the 354A, sexual harassment by punishment for sexual, then जो इसके अंदर आपको थोड़ा सा वो क्या है कि इसको ये डिफाइन भी कर दिया है कि आपका क्या सेक्सुअल वो होगा. So if a man committing any of the following acts, it is given there: physical contact, if he is trying to do the physical contact, and advances involving unwelcome and explicit sexual overtones or a demand or request for sexual favors. बहुतों को पता नहीं है इसका कि it is an offense if somebody demands or requests for the sexual power, or showing pornography against the will of the woman. If somebody is sending the porn literature to somebody, some woman, then making sexual colored remarks shall be guilty of the offense of sexual harassment. That is, they have defined the sexual harassment. And the punishment for sexual harassment, that is up to 3 years or fine or both, up to 1 year in the second case, and the offense is cognizable It's a non-compoundable, that is we leave aside. Then section 54, 354B, that is the assault or use of criminal force to women with intent to disrobe. That is there, it has been included if somebody with the intent to disrobe. Any man who assaults or uses criminal force to any woman or abets such act with the intent of disrobing or compelling her to be naked. So they compel her to be naked. Then the punishment is 7 years, but less than 3 years. The minimum is 3 years. Then section 354, that is the voyeurism. If any person who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed, then it is an offense under section 354C, and punishment is on first conviction, the punishment is which should be not less than 1 year and may extend to 3 years. And for the subsequent conviction, the imprisonment should not be less than 3 years and which may extend to 7 years. That is what the voyeurism. So now 354D. D is stalking. Stalking is there in the IT also. We talked about the stalking, bullying and stalking. So if any man who follows a woman and contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman, then or the monitors the use of by a woman of the internet, email or any other form of electronic communication. So the IT Act it is mentioned, but in 354D also they have specially mentioned that if anybody monitors the use of women of an internet, email or any other form of electronic communication commits the offense of stalking. They have defined the word stalking, provided that such conduct shall not amount to stalking if the man who pursued proves that it was with her. That is altogether a different thing. So the offense of stalking is, the punishment is up to 3 years with fine and may extend up to 5 years for the subsequent offenses. Now then section 375. Then 375 is about the rape and need not to discuss that. It is done without the consent. The offense is that of rape. Then section 376, that is the punishment. So need not to discuss, this is everybody knows it. So now then 376, intercourse by a man with his wife during separation. If during separation her husband wants to commits the sexual intercourse, then it is imprisonment for natural life, but less than RI for 20 years during separation. So severe. Second, section 76AB, that is the punishment for the woman. That section says about the offense of rape on a woman under 12 years of age, and the severity is there also. The imprisonment is for the natural life, but it is not less than rigorous imprisonment for 20 years. That is the minimum. 376B. Then 376B, intercourse by public servant with a woman in his custody. Then punishment is 5 years and fine. The word intercourse is mentioned, not the rape, because even if it is done with the consent of the lady, then also the punishment is up to 5 years, because the lady was in the custody of the public servant. So that is there. Now 376C, if the intercourse is by the superintendent of jail or remand home, if the lady is in the remand home, then even if it is with the consent of the lady, but if the jailer or the in charge of the remand home does the intercourse, then it is an offense under section 376C, and the imprisonment for this is up to 5 years with fine. Is a cognizable offense. Then we hear about the gang rapes. So in 376D there is a section of gang rape where a woman is raped by one or more persons, then the punishment is imprisonment for natural life, but not less than RI for 20 years. These are the severe punishments. Then 376 DA is a punishment for gang rape on a woman under 16 years of age. Then the imprisonment for natural life and fine, and it's a non-bailable, that is there, non-bailable, cognizable and non-compoundable. Then this is 376 DB. We are discussing the latest as on date. The IPC has also been amended looking to the cyberspace, because people are using the computer resource system, the internet and all that. So all these are included in that. And this is the punishment for gang rape on women under 12 years of age. And under 12 years of age, again the punishment is enhanced. It is the punishment imprisonment for natural life or death, whichever is earlier. Then 376E, punishment for repeat offender. And punishment for repeat offender of what? Of 376, 376A, 376AB, 376D, DA, DB, which we were discussed just now. So the punishment is for natural life or death. That is there. Then comes the section of defamation, because in the IT Act there was a section 66A that was for the defamation, but the Supreme Court struck down that section. 66A is there in the Act, but it has not been used by the prosecuting officers or the police or the courts, because it has been struck down by the. But in case of defamation, section 499 exists. So what does that section say? If anybody by words either spoken or intended to be read, or by signs or visible representation makes or publishes any imputation concerning any person intending to harm or knowing to have reason to believe that such imputation will harm the reputation of such person, is said to actually commit the offense of defamation. Section 500, there is the punishment for defamation, and the punishment is up to 2 years with fine with both. But this is non-cognizable. So police cannot take direct action under the section 499 or 50 defamation. So they add some other sections which are cognizable, and they register the case. Then section 506, this is punishment for criminal intimidation. We are talking about the sections which are related to the gendered cyber violence only, not other cases. So then section 506, that is all in the, I think, IPC related to gendered cyber violence. Then the next, I think 1-2 more sections, but need not to 507 or 509. Then comes the Protection of Children from the Sexual Offences Act 2012 and Amendment Act 2019. We will start from section 4 of the Act, the children, which is also called the POCSO Act. So this is a punishment for penetrative sexual assault not less than 20 years, but which may extend to imprisonment for life. It says whoever commits penetrative sexual assault on a child below 16 years of age, यहाँ एज दी है 16 ईयर की, shall be punished with imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of natural life of that person and shall also be liable to fine. And the other important section is section 6, and that is the punishment for aggravative penetrative sexual assault. And the punishment in aggravated assault is not less than 20 years and which may extend to imprisonment for life and fine. And what does this section say? It says whoever commits aggravated penetrative sexual assault shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment of life, which shall mean imprisonment for the remainder of natural life of that person and shall also be liable to fine, or with both. The fine imposed under this section shall be just and reasonable and paid to the victim to meet the medical expenses and rehabilitation of such victim. This is the importance of this section. Now section 8. This is the punishment for sexual assault not less than 3 years, which may extend to 5 years and fine. So whoever commits sexual assault shall be punished with this imprisonment. Then next is the section 10. Section 10 says whosoever commits aggravated sexual assault shall be punished with imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 7 years and shall also be liable to fine. Then section 11, this is the sexual harassment. So what is a sexual harassment? A person is said to commit a sexual harassment upon a child when the person with the sexual intent utters any word. You see, this is important. If anybody with sexual intent utters any word or makes any sound or makes any gesture or exhibits any object or part of body with the intention that such word or sound shall be heard or such gesture or object or part of body shall be seen by the child. तो आप देखिए कितना इसको एक्सप्लिसिटली वो बताया गया है कि आप कोई शब्द हैं, कोई आपकी साउंड है, या कोई भी आपका गेस्चर है, या कोई आप एग्जिबिट करें, कोई बॉडी का पार्ट बताएं या कोई और ऑब्जेक्ट करें, और इंटेंशन उसका ये कि वो बच्चा उसको देख ले, उसको सुन ले, और इंटेंशन आपका सेक्सुअल उसके अंदर है. एंड सेकेंड, makes a child exhibit his body or any part of his body so as it is seen by such person or any other person. अपने अभी आईटी एक्ट के अंदर ये देखा था, ऑफेंसेस के अंदर एक आता ग्रूमिंग. तो ग्रूमिंग का क्या रहता है कि पहले उसको अपने उसका हितैषी बन के और उसको विनोवर कर लेते हैं. विनोवर करने के बाद में फिर उसके जैसे उसकी बॉडी को कहते हैं तुम्हारी मसल्स बहुत अच्छी हैं, ये बहुत अच्छी हैं, उस तरीके से, या कोई वो लेडी बन के या लड़की बन के लड़की से वो बात करके, तो उसके अंदर यदि आप उसको बॉडी के पार्ट को दिखाते हैं तो ये इसके अंदर भी आपका ऑफेंस में आता है. शोज एनी ऑब्जेक्ट टू ए चाइल्ड इन एनी फॉर्म और मीडिया टू फॉर पोर्नोग्राफिक पर्पज, ये भी इसके अंदर सेक्सुअल उसमें किया हुआ है. और रिपीटेडली और कॉन्स्टेंटली फॉलोज और वॉचेज or contacts a child either directly or through electronic, digital or any other means, or threatens to use in any form of media a real or fabricated depiction through electronic, film or digital or any other mode of any other part of body of the child or the involvement of the child in a sexual act, or entices a child for pornographic purposes or gives gratification therefore. It is defined in this. Then is the section 13, that is the use of child for pornographic purposes, and that is the of this offense, the punishment is not less than 10 years. In the case of child below 16 years and not less than 20 years. नॉर्मल केस के अंदर तो 10 years है, not less than 10 years. But if the child is below 16, then it is 20 years. So whoever uses, देखिए इसमें डेफिनेशन जो दिए हैं सेक्शन 13 के अंदर, whoever uses a child in any form of media including program or advertisement telecast by television channels or internet or any other electronic form or printed form, whether or not such program or advertisement is intended for personal use or distribution for the purpose of sexual gratification. And what that sexual gratification mean? Sexual gratification includes representation of the sexual organs of the child. That is the, and second, the use of child engaged in real or simulated sexual acts with or without penetration. The indecent or obscene representation of child, that is also included in the definition. And if he does any of these three, he is the guilty of offense using a child for pornography purposes and is punishable. Then section 14, it is very exhaustive, it covers all these, that the punishment for using child for pornography purposes. So whenever whoever uses the child for pornographic purposes, then the punishment is for the term which shall not be less than 5 years. And anybody who commits any of the other offenses, then the punishment is enhanced. Then another is section 15, the punishment for storage of pornography material involving child 3 years. This is very important. If somebody stores the pornographic material in which the child is involved, so any person who stores or possesses any pornography, the possession is also an offense. The storage is also an offense of the pornographic material in any form involving a child, but fails to delete or destroy or report the same to the designated authority, as may be prescribed with an intention to share or transmit child pornography, shall be liable to fine, and punishment is 3 years. It's a 3 years fine and with fine. And then in section 42. Section 42 says, suppose someone is guilty of offense under section 354 also, and under the POCSO Act also, where an act of omission consists an offense punishable under the POCSO Act as well also under the IPC section 166A, 354A, 354B, 354C, 354D, 370, 370A, 375, 6, 376A, C, D, E, or section 509 I of the IPC. The code which provides the punishment with a greater degree will be applicable. So we have discussed the genesis of cybercrime, its modus operandi, technique, legal aspects in an exhaustive way. The various studies and researchers reveal that the reporting of cyber violence is a very low in comparison to the crimes committed. And if we talk about the gendered cyber violence, the reporting is even much less, or say minimum. There may be various reasons, but the common reason reported by various studies are, and number one, they say the victim woman or girl feels that the reporting of abuse is normally misconceived by the society on the principle of logic. What is the logic? If there is a smoke, there must be some fire. On the logic of perception of the public points figure on the victim also, resulting no complaint by the victim. She says people will finger on me, at me, so she doesn't report the matter. Number two, 30% of women who experienced online abuse intentionally reduce their online presence. They reduce the online presence. उन्होंने अपनी ऑनलाइन पे प्रेजेंस ही वो कर दी. Number three, then the victim women was not supported for reporting the matter to the police by the family members and friends. फ्रेंड्स फैमिली मेम्बर्स ने कहा कौन झंझट में पड़ते हो, पुलिस कुछ नहीं करेगी और आप उसके, सो दे आर नॉट सपोर्टेड बाय विक्टिम, हर पेरेंट्स, देन गार्जियन, टीचर्स एंड फ्रेंड्स, दे डोंट नो लॉ. उनको ये पता नहीं है कि इट इज़ एन ऑफेंस एंड सीवियर पनिशमेंट इज देयर. उनको ये लगता है कि कोई होगा तो है नहीं, कोई ऑफेंस पता नहीं है कि नहीं है बेसिकली. तो उनको इस चीज़ का पता नहीं है कि इसका ये एक्ट से पनिशेबल है. एंड लास्ट, जिसमें आप उसके पार्ट हो जाओगे, जैसे आप ग्रेजुएशन कर लोगे उसके बाद में, another important is not trusting the criminal justice system. This is very important. They don't trust the criminal justice system, that is to say the law enforcing agencies, the investigating agency, the police, the prosecution agency, the lawyers and the judiciary. That is all. Thank you very much.